Good afternoon, everyone. Thank you very much for joining this webinar. As the topic suggests, today we will discuss the interplay between the General Counsel, the lawyer, the counsel, and the forensic expert in an internal investigation. Now, before coming to the panelists, I will briefly give an introduction and set the context. Now, internal investigations are an essential tool for crisis management and works as an effective remedy for unwanted and embarrassing raids or searches by authorities. Now, this is a relatively recent phenomenon in India, and over the last 5 or 7 years, we have seen a surge in internal investigation. These are issues which potentially arise out of internal complaints, external complaints, complaints made by whistleblowers, disclosures made during the audit, or sometimes the company can take suo motu cognizance of a wrongful act as well. Now, these complaints typically, they are premised or they are based out of misconduct. It could be criminal offenses such as fraud, corruption, bribery, infringement of company internal rules, charter documents, manipulation or tampering of documents, financial records, misappropriation of funds, unethical business conduct, falsification of transaction, money laundering, so on and so forth. Now, in today's panel, we will discuss the broad legal framework and the procedural nuances which are involved in conduct of an internal investigation. With this background, may I now invite Payel to sort of briefly tell us. So, internal investigation, as I discussed, it's not a very old phenomenon in India. We started maybe since five or last 7 years. This has been going on. So, when did it all start, and what is the legal framework regulating conduct of such internal investigations?
Thank you so much, Alipak. Very good afternoon to everyone. I think Alipak has put me on the spot and under a lot of pressure when I have such stellar co-panelists who will come after me. So I have to set the tone right for this particular session. Coming back to Alipak's question, yes, as you rightly said, it is a recent phenomenon. It's not something that a decade back we knew multinationals or Indian companies actually investigating internally, looking into what is actually happening inside their houses. But we have seen a shift. There has been a change. There has been, I would say, a change in mindset. Now, what is the cause for the change in mindset? More and more, corporates have realized the need for having or how critical it is corporate governance itself. Directors on the board have realized their duties. There is much more awareness which is there. And I think last but not the least, the very fact corporates have taken a very strict stand when it comes to fraud, bribery, or any kind of corruption. It is a strict no. It is unacceptable. So the minute the corporates take that kind of a position, automatically you need to see a change in mindset and a diversion, or the fact that I would say prioritizing the fact that if there is an issue, one needs to address it. And that's the reason we have seen a growth or a surge of internal investigations. Moving to the next part, what is the framework? I can't give you a yes or no answer. There is no set procedure in place. There is no legislation or background which would, or a statutory notification which says this is the process you need to follow or you need to comply with this. So obviously we do not have a legal framework, but there are other things which actually help and assist you in running an internal investigation. Most MNCs these days have policies in place. They have a code of conduct. They have a whistleblower policy, a grievance redressal mechanism. Now, what these policies do is they identify acceptable as well as unacceptable behavior, what employees or other stakeholders are required to comply with, who all are these policies applicable to, and in case there is any kind of issue which is reported, in such a scenario, how do you go about addressing it? And what are the steps which are required to be followed? So within the broad parameters of that, I would say an internal investigation typically is run when it comes to.
Thank you for that, Payel. Now, if I can sort of add on to that. So I briefly discussed what are the trigger points for initiation of such kind of an investigation. Now, could you, in your experience of dealing with these kind of issues in last 5 or 7 years, could you tell us briefly what are the instances which usually trigger such an internal investigation? I mean, it could be a whistleblower complaint, or it could be a fund embezzlement, so on and so forth. We know, but in your experience, what are the kind of issues that you have seen in the recent past?
Thank you, Alipak. I think you have already pointed out in the introduction the various issues which get covered actually lead to an internal investigation. So, but what are the mechanisms, or I would say what leads to that internal investigation? It could be a complaint from an employee. It could be a complaint from an external source. It could be from any other stakeholder. It could be something which is disclosed as part of the process, or even a suo motu cognizance which is being taken by a company. All of this put together, it could be any one of these situations, which is pertaining not necessarily to a financial issue or a fraud or an irregularity. It could be a general misconduct, non-compliance or non-adherence with any breach of that. All of that could go to an internal investigation.
Sure. So, Alipak and Payel for that initial, background and putting the landscape. And we would discuss this in greater detail, particularly with Gopi and Gagan being part of this panel. So let me first go to Gopi, and the whole investigation as a topic. I think it all starts as the last point Alipak and Payel were discussing as to what are the triggers, right? In my experience, Gopi, we have seen that there is a clear shift in the whole whistleblowing regime, particularly in India. While there are certain statutory requirements for a listed entity, but at least we have seen that even private companies and public unlisted companies and other types of entities have also create a robust mechanism for whistleblowers to come up and talk about the issues, and it makes actually a sense to do that, because you better are told by someone in private rather than wait for a regulator to come and then hound you for any non-compliance. So I think people have also realized that it is better to put your house in order in this manner, because it also solves a lot of issues internally, and it also allows the company to be much better prepared if at all external agencies are or would be involved, going forward. So we have seen people have started becoming more and more and some of these provisions. But what is your take on it? How do you see this growing in large and medium-sized companies in India? How this can be used as a tool rather than run away from it? And then what are the essential steps you take, immediately after you get any of those complaints? What is your experience on that?
Thanks, Vyapak. I hope you can hear me all right. And
Yes,
good afternoon. And Payel, you did a fantastic job setting the context. So thank you for that. So let me kind of address one of the key issues, Vyapak, that you raised, which is this is no longer about what is, I think, regulatorily or statutorily required. I think more and more people are seeing that having a robust whistleblower program in general is a question of trust. And how do you foster that trust, not just with your employees, who are your key stakeholders in this process, but with investors, with vendors, with the world at large. I mean, this has kind of become a key element of doing business. And I think having trust ratings go up, or the quotient of trust can go up, is very critical for businesses these days. And that's really the reason that you're seeing more and more private entities, people are not kind of even required by law to kind of maintain a whistleblower program, invest in this area. Now, as far as WNS is concerned, we obviously kind of take this very seriously. We've obviously covered by Indian law having been incorporated here, but we're also listed in the New York Stock Exchange. So we've got obligations both under Sarbanes-Oxley and other kind of legislation, the FCPA or the UK Bribery Act. View in that sense, in terms of obligations to investigate these matters. So we've invested, in a fairly strong whistleblower program that's managed by a third party, and I think that's kind of where the world is headed to now. So that kind of gives a little bit of comfort to potential whistleblowers that these matters being recorded and tracked adequately. And internally, once we receive a whistleblower complaint, obviously, I think the first thing to do is conduct a quick triage of what the issues are likely to be, separate, the chaff from the grain, if you will, and we spend some time kind of looking at what are the key issues being raised in a particular complaint. And I think, just kind of at high level, what that helps us do is obviously conduct an initial risk assessment that becomes critical for determining what the scope of the investigation should be. And obviously that can kind of be adjusted as the investigation moves forward, new facts are gathered, we can kind of, figure out if the scope of the investigation needs to be broadened or whether it's more narrow in scope. What I'd recommend for most people to do is actually just build a detailed investigation plan once you've got an assessment of what the scope of the investigation should be. And, really kind of just identify tasks, deadlines, the people who will actually be responsible for various aspects of the investigation. And then, I think it's critical being in-house counsel that we kind of coordinate regular update meetings to make sure that, the progress on the investigation is tracking per plan, and also kind of provide updates to stakeholders within the organization that is updated. And I think, equally critical as you kind of talk about stakeholders is actually making sure that we've got early support from the executives, whether it's the CEO, whether it's the CFO. That's, I think, where the art comes in, making sure that there is adequate disclosure internally, but not so much that it could potentially compromise the investigation itself. And I think one other point that I'd make in that connection really is identifying who your client is. Is it the company? Is it the audit committee? Is it a particular individual involved? And I think we can talk a little bit more about that, but let me kind of put that out there because I think that's a critical element of what in-house counsel kind of need to make a determination about as well. And then finally, I think, depending on the scope of the investigation, kind of identifying who should lead this investigation. And I'm sure we'll spend more time talking about that, Vyapak, but, who do we get involved? How do we kind of make sure that there is privilege around, the investigation? And how do we deal with the actual subjects of the investigation? So I think those are the things I think early on you kind of really frame and make sure it is absolutely clear.
Sure. So I have two follow-up questions, Gopi, and then maybe Alipak may have something to ask. But so you interestingly said one thing that now even some of these whistleblower complaints or the programs are even run by third parties. Can you explain or at least give us an idea what does that mean in terms of, is it only the technology or is it that the decision making is also at that level up to a certain stage of investigation? And two, many a times, particularly when whistleblowing happens, a lot of senior people are also sometimes involved. Sometimes even certain members of the board is involved. You can't segregate some of those from one to another. If it is financial issues, then you may not even be able to go to audit committee because we don't know how far and who is involved at that early stage. So there are
Yeah.
several of those critical decisions which are required to be made right at the start. So I'm a little curious to know, when you say third parties, uh, uh, how do you balance these two aspects? And uh, of course, there has to be some independent source who receives those complaints, because even sometimes even legal counsel or an HR head can be involved as part of whistleblowing program. Of course, there are alternate emails for those things, and programs are sometimes robust to address those concerns. But when it involves third party, where do you draw a line? Can you give a little clarity on that?
Sure, Vyapak. So, like I said, I think the initial analysis of the complaint will kind of leave, me a sense of what are the issues involved. And then I think that kind of starts analysis of who can potentially be involved. Could a regulator be involved? Are there disclosures that are potentially required to be made? And depending on the gravity of the situation, it can also give you a sense of whether there are senior executives within the company who might be impacted through the course of the investigation. And I think that kind of leads to the decision as to who should lead the investigation. Obviously, in matters that you need privilege, that you need, as potential interactions with regulators, my first choice would be kind of identifying external counsel who could kind of do that. And that again, I think is, based on the gravity of the matter and effectively trying to figure out, do those steps kind of provide legitimacy to the investigation, in that provide assurance to a regulator that they can rely on the results of the investigation, right? A lot of the time, I think that's the foremost consideration for me. I mean, if you have a regulator that's potentially involved, make sure that there is sanctity to the investigation process. Obviously, there is a big consideration around preserved best by kind of, including external counsel or having external counsel lead investigation. And then finally, I think,
Sure.
the other thing is, could this be potentially subject to undue influence by employees of the company? And therefore, is the better course of action kind of going to an external party to investigate? Outside counsel, and typically now, as you kind of more and more seeing financial fraud, obviously the key role that people play in it are the forensic investigators as well. I've unfortunately had the misfortune of having to engage forensic investigators as part of my career. That kind of tells you that it's a fairly serious investigation, but that's the best way of doing it, because then you kind of secure information. You make sure that there is no possibility of evidence being tampered with, or if in fact there has been evidence that's been tampered with, then kind of getting to the bottom of
Sure.
what the facts are. So those are the two key components of I think conducting an investigation that will be seen as unbiased and
Sure.
secure in that sense.
Understood. And we'll come back to this topic a little bit, because I think we would also want to discuss a couple of other issues. One is the aspect of identity protection for the whistleblower, and also that he or she is not subjected to any retaliation or any consequences for doing this, right? So how do you manage that? And there are softer and other issues involved as part of that process, but we'll come to that little bit. Maybe I'll hand over to Alipak to continue with other questions to maybe Payel and Gagan.
Yeah. So before we move to Payel and Gagan, I had one last question to Gopi. I mean, how do you sort of manage the early stages of investigation? And to be more specific, so in many instances, we are seeing that the entire investigation is managed by the internal team. So what are the challenges you face, especially in terms of maintaining confidentiality, so on and so forth? And is the treatment, is the investigation slightly different when senior management is involved? How do you go about such an exercise? I mean, especially before you engage a lawyer or a forensic expert.
Yeah, I mean, and I don't mean to kind of trivialize the types of issues that in-house counsel deal with. And I think clearly where it's a violation of internal policy, code of conduct, there are a bunch of issues that internal counsel look at and investigate. And I think the real challenge I think I found in all of this is preserving confidentiality. It's human behavior. Your lawyer calls you one morning and says, "I'd like to have a chat with you." I think your first instinct is to pick up the phone and call your manager or someone else. So despite kind of, encouraging them to keep it confidential, I think that's been the biggest challenge that I've seen. But it's, I think there's a path to completion on a lot of these issues. It really is about making sure that you kind of spend the diligence, making sure that you kind of correct your internal policies, and brief the people that need to be briefed. Environment is kind of hard, but I think the art is to try and find out and keep involved in the and making sure that you're kind of providing updates on a reasonable basis. So the breach of policy type issue, that's been my biggest challenge. The other thing that we need to kind of then also lawyers is their lawyers and make separation. And when you're kind of working to kind of business, but the in-house counsel is actually primarily to kind of the company and not individuals within the company. The other point that I'll make in that connection, Alipak, is also just make again the definition of who the client is, and sometimes it's necessary to kind of make sure that you take this to the board investigations where the audit committee or a subcommittee of the board basically over the investigation. And that's to make sure that, a separation standpoint, you're not representing, again, executives within the company or the company itself, but a broad interest and corporate interest as well.
Yeah, I think you took a very, very important point as to how do you segregate the interest of the company versus the senior executives, sometimes even the board itself. And of course, there is an independent audit committee, if at all, in certain situation, particularly in a listed entity. So I think that's, in my view, the most critical decision you make at the initial stage. And unless you do that right at the start, I think you will always fall short of doing what you are supposed to do as part of such a complaint, because then once you make a wrong decision at the start, it's very difficult to catch up. So yeah, Alipak, go ahead.
Yeah. Thank you so much for that, Gopi. Now with this background, so now we have understood sort of what are the initial stages and then how the in-house team conducts the process. Now the next question sort of is, what is the right investigation team? Now let me quickly come to Gagan for this. Now, keeping the practicalities of conducting investigations in India, what would typically be a right investigation team, or how do you go about choosing an investigation team?
Sure, Alipak, and thank you for that, and good afternoon, everyone. This March, I completed 20 years of being in forensic in India, and it set me back thinking, what has really changed? You started by saying last 5-7 years, a lot of things have changed, and similarly, when we think about investigation teams, or even how investigations have changed, it's pretty interesting. So 4 things which I think firstly have changed, and that leads to the composition of how investigation teams have changed. So the first actually is the definition of what is misconduct. So earlier in my career, the first year I was in forensic, I went to do an investigation in a company, and this was an allegation against the CFO, and it was potential siphoning of funds. So I spent a lot of time, 3 weeks, going through every transaction, like pretty much like a pit bull running down in the trenches and tearing every piece of paper up and building a case. And I go to the presentation, with the CEO, and I tell him, "Look, sir, I found the fraud." And the CEO tells me, "Arey, what have you done? These are my entries. I told you to find what the CFO has done." So so I couldn't believe it that a company could have a differing stand of what was permissible or what constituted misconduct by the CFO, but was absolutely acceptable for the promoters, CEOs to do the same. So that definition to me has changed. The second part, in most investigations we did, excepting if I take into account the first 10 years of my career, companies were very happy with, when somebody walked away. The objective of an investigation was call the guy for an interview, get a resignation letter signed, we will pay him 3 months of salary, and please let this person walk out of our premises, and goodbye and good luck. So we will all carry on business as usual. The third important aspect was there was an inherent reluctance to go legal. I have to say, the first 10 years of my career, maybe in 10% of the investigations, I saw the GC involved. Compared that to today, to 95 to 98% of our investigations are where in-house counsel and external law firms are involved. And the 2-3% where they're not involved is probably an investigation against the legal department. So, that's really the play that which we are looking at. So that's really undergone a change. And lastly, I think, and most importantly, the disclosure requirements. I think today, there were so many investigations I've done in my career, which the auditors never got to know, which the board of directors never got to know, which at times the CEO never got to know because one particular, for a group in the company was trying to do something. But to me, all that has changed. And because of these changes, there's been a fundamental change in how we constitute investigation teams. Because firstly, evidence has become extremely important. So, the way you collect evidence, whether it's digitally, and today, we live actually last 4 months, I don't think we walked into maybe 10% of the cases we are walking into clients, 90% is being done remotely. So everything, how you gather in intelligence, how you gather evidence, and collect all of it and put it down, that becomes important. The second part, when one talks about an, constituting an investigation team, to me, the most important part is the subject matter expertise. You can't take a rookie and tell him to, look at some extremely complex IT contracts without the person having any clue of how revenue recognition on an IT contract works. You cannot take a person who's never been on a construction site and tell him go find, where the extra material has been procured, because the guy will have absolutely no clue. So we are now dealing with some very nuanced frauds. We are dealing, with, let's say, large, complex financial services investigations related to siphoning of funds. If a guy doesn't understand how a banking system works or how a loan is given or what documentation goes on top of it, it's going to be an absolutely clueless internal investigation to think of it. So to me, the large competencies one thinks of today is subject matter expertise, which basically means getting an ecosystem of possibly people who may not have investigative experience, but making sure your team has the skill set to deal with the complexity of what's happening. The second is, today I would say technology and digital enablement of an investigation team is key. You need to have people who understand technology, who go behind a financial system. And I'm just going to give an example here. About 10 years back, and I grew up in the old world, and I'm a chartered accountant by profession, where I could look at a page and total it. So I was looking at these printouts of an account, and just a page total, when you have those debits and credits at the end of the page, they didn't seem to really tally. So there's something off. So we actually went into the program and we found that somebody had changed the system. So every time the auditor went and queried a particular account, the offending entries would not show up. So it would never form a part of your audit sample, and those frauds would never get detected, because for this very simple reason, the printout for the auditor did not have those entries in it. So technology, understanding technology and going behind the curtain to really see what's happening at the back end becomes extremely important. And I think intelligence, to me, is the third interesting component which one needs to have and needs to sufficiently increase. And lastly, I would say legal oversight. Today, in today's environment, in today's litigious environment, where even after you're literally catching a person with all the evidence in the world, with complete and utter, I would say watertight cases, we still have cases where people are coming back and saying incorrect termination, or I'm going to go legal against the company for defamation or whatever. So, just the legal oversight right from day one over the process is extremely important. So I think to me, when I'm constituting an investigation team, somebody said, years back that there are 5 things one needs to think about. It's experience, methodology, mindset, experience, and experience. So experience comes thrice in this being of 5, because, each and every person you pick to constitute an investigation team needs to be highly experienced and highly nuanced, especially in times like today. So back to you, Alipak.
Thank you so much, Gagan. That was very insightful. Now, I'll ask the same question to Payel to sort of give a understanding of, from the lawyer's perspective, what could be the right team? How do we sort of map the right members and then carry this exercise?
Thank you, Alipak. I think Gagan beautifully summarized it, the key elements which are there about evidence, intelligence, experience. But I think what I felt in my limited experience so far is each situation is very unique and different. you don't have actually a straight jacket formula which can be applied to every investigation. Obviously, the subject matter differs. It also differs what kind of an organization you are dealing with, whether it's only maybe India focused or it's a multiple jurisdictions are involved, comply with a lot of foreign laws as well at the same time. So that's precisely the reason you see a lot of co-counsel work happening these days, because you need an expert from US, UK, and India. And the next part is when you have involved a financial, as Gagan rightly mentioned, an accountant, a forensic expert, which is the ideal team for that particular. Now, obviously, as we mentioned earlier, that we don't have any laws or formula or legislation in place to go about it, except when you have a sexual harassment complaint. But for every other complaint, you tailor make it depending on the requirement itself. And the next aspect also, which involves is who you are reporting to at the end of the day, whether you're reporting to the GC itself or you actually have an audit committee in place whom you are reporting to, because you need to ensure that the confidentiality is maintained. There is no element of bias which is involved in the entire process. So I think it's a multiple factors, the environment around it and what the situation demands in a particular case, which actually leads to constituting the correct investigation team, I would say, for a particular matter.
Also, let me add one point here. I think when a complaint comes, whether it is formally or informally, typically it would obviously come to the internal people, right? And there would be always some level of predetermination, prejudice, bias, influence, or some kind of an, overhang of something which that person may or may not be aware of because of the past experience. I think the most critical part about setting up a team is you need a team who is not starting with a predetermined uh, thought process that okay, this is the allegation, now I want to prove it is right, or most of the time it is I want to prove it that it is wrong, right? I think you need to really work hard to make sure that people involved goes into with a very very clear mind and an open mind for the investigation. So while I agree with Gagan in terms of what all is required in terms of the expertise, experience, and uh, the issues involved, but I think on a softer side, I would add that you cannot have a team who goes with a predetermined mind. So whoever has any sort of that element involved, should be a part of the team. I think that's the starting point in that issue.
No, absolutely, Vyapak. I just want to add, I think what you said is absolutely spot on. As an external investigator, there's so many times when we are called in, and the clients say that, this is a witch hunt. It's turned into a witch hunt because internally the way we're looking at it, or other people we've got in are looking at that. And, to me, and honestly, I'm sure you guys have the same thing. It is so easy to say that someone has done something wrong, but to actually come back and say that nothing has happened, and to then sit before a regulator and actually say, so every step that you need to follow, has to be double ticked, triple ticked and
Sure.
quadruple ticked just to make sure. So cannot, I just want to reemphasize what you said is absolutely spot on. And to me, that resonates so much with a lot of the companies we work today. Just that, the point is having objectivity in an investigation and not looking it through a colored glass. Top of the mind actually today. So thank you for.
And the second point, I think Gopi mentioned earlier a couple of times, and I think Gagan also mentioned a little, is the whole aspect of privilege. And this whole dovetails into the aspect of when do you, build a team to ensure that you don't lose privilege. Because people don't understand that privilege can be lost even when a part information is out, right? And then you can't bring back the privilege in because everything done later on is of no consequences if the main issue is already in the public domain. And so maybe Payel, if I can bring you on that aspect, because this is a nuanced legal issue, particularly in India, it is clear from a perspective of the Evidence Act but it is not clear in perspective of investigations. While we have some, guidance from UK and US, but if you can spend a couple of minutes on how this law has evolved externally and what we expect it to be in India as we go further.
Thank you, Vyapak. I think it's the most trickiest portion of the investigation of addressing the privilege issue. Now, a client-attorney privilege, obviously, that's a concept which is known for several years. But whether it extends to investigation or not is something which has been debated in the recent past. Unfortunately, in India, we do not have any specific legislation or judicial precedents which deal with the concept of attorney-client privilege in the investigation context. In the absence of that, India being a common law jurisdiction, we have always gone back to see how the law has developed in UK. Now, UK and US had two different approaches. Going back to US obviously goes back to like several decades where we started to have the Upjohn ruling itself, which explained the concept of an Upjohn ruling and also the concept of a litigation privilege, what is included in case of an investigation. So provided you can prove or establish that all documentation, all communication which have been exchanged between the client and the attorney is towards the predominant purpose or a sole purpose of a litigation, to that extent it gets protected. But when it comes to UK, it has actually heavily debated in the last 5 years as to what constitutes privilege in investigation. They have actually divided it back into legal advice privilege and a litigation privilege under the broader umbrella of actually legal professional privilege. Now, litigation privilege is something which is fairly simple to some extent, that, okay, it's towards the purpose of a litigation, which may arise or bound to arise in future. So towards that purpose, that communication gets protected. But legal advice privilege, that's something slightly different. Kind of communication where a lawyer and their client are exchanging and giving certain advice, that constitutes legal advice privilege. But when the client is exchanging information in the pursuit of getting the legal advice, whether that also gets protected or not was one of the issues which was discussed in two rulings in UK. One is the ENRC ruling and the RBS ruling. These are two rulings which came up in 2016 and 2018 with having slightly different views and perspectives when it comes to privilege in UK. Privilege in UK later on in ENRC ruling went on to say, even the documentation which you have exchanged in obtaining legal advice, the information which you have shared, all the documentation as part of the investigation process also which has been exchanged between the client and the attorney, that also gets protected. Though RBS had initially said that won't get protected because that's factual in nature. It's not actually any kind of legal advice which you are rendering. But we still don't have any finality. It's a debate which is still ongoing in UK, because with every ruling, with every new fact situation, we are seeing how the courts are looking into this particular issue of privilege and actually maybe trying to even differentiate it when it comes to legal advice and litigation privilege. Coming back to India, as I mentioned earlier, we do not have judicial precedents or any kind of legislation. In India, it's primarily governed when it comes to the Evidence Act, as well as thanks to our Bar Council Rules and Advocates Act. It says somebody who is enrolled with the bar. In that situation, that attorney is actually protected under the concept of the client-attorney privilege. What works for in-house counsels is still a gray area, because we have had some rulings in the Bombay High Court which dealt concept of privilege and said whether it should be extended to in-house counsels or other professionals as well. But till date, we don't have any law or actually a law of the land by Supreme Court ruling on this particular issue of extending this privilege to in-house counsels. So it being such a difficult issue, it's like unless you have clarity, it's actually like walking on the rope almost, because you don't know where it slips out and this conversation is not going to get protected. So, I mean, it's tricky. And I think that's the reason, I mean, as a suggestion or as I mean, as legal external counsels, our advice always is engage the external counsel, put the engagement letter in place, then go about engaging the forensic experts so that you can ensure their engagement comes within the ambit of attorney-client privilege. Thank you, Vyapak.
Thanks, Payel. So I think the short point one needs to take into account is while in India we all are aware of the litigation privilege when it comes to Evidence Act and court, because it is purely for litigation. Any advice or legal advice taken where dominant purpose of that advice is not, an expected litigation, there is a gray area, particularly if your engagement and your scope of services are not, clearly defined. Because just because a lawyer does an investigation doesn't mean it's privilege, and vice versa. If anybody else does investigation, it doesn't mean privilege. And you need to be very, very careful as to how you word your scope and whether it is for sole or dominant purpose of potential litigation. Because otherwise you are basically doing a job of a third party regulator, giving everything on a platter that, look, we found this, and then please, take an action against us, because it's a perfect recipe for a regulator to ask for that report. Now, this also, dovetails into a couple of questions which are there in the question window before we go on to the next set of topics. There is one interesting question from Rohit Jain, and maybe Gagan would love to answer this. What are the qualifications one must have to specialize in forensic investigations? So maybe Gagan, if you want to answer that. Yeah.
So Vyapak, Gagan is just joining back.
Okay.
I think,
in the meantime,
some technical issue.
Yeah, no problem. In the meantime, Gopi, there are one or two other questions which are in reference to the whistleblowing, and maybe if you want to take those, as to one, whether it is part of the policy or not that reports after you conduct a complaint investigation are necessary or mandated to be, given to the whistleblower. How do you handle those reports? While we'll deal with the report making as a separate topic, but if you have a quick comment on Mr. Kishore's question here.
Yeah, sure, Vyapak. So, obviously there's no legal requirement that an investigation report itself is shared with the whistleblower. Typically, what ends up happening, I think, Kishore, is if it is a material investigation, obviously there's an obligation to disclose, the fact that an investigation is being conducted to the stock exchanges. And, I think even in kind of prominent cases in India, the companies have basically reported on progress and conclusion rather than actually issuing the report itself either to the regulators or to the whistleblower. So, I think the whistleblower can obviously kind of understand that, the investigation is ongoing. As a practical matter, what happens when in-house counsel kind of receives a whistleblower complaint is your first source of information is obviously the whistleblower. So we tend to kind of reach out to the whistleblower and get additional information if possible. A lot of the time complaints are vague and non-specific. So you want to kind of try and figure out what are the facts, who can provide more information. So, that in itself will enable the whistleblower to kind of understand that, actions being taken, in regard to that complaint. But, there are other considerations to keep in mind in terms of the report, because, we just kind of wrapped up talking about privilege. And a lot of the time, you kind of, as in-house counsel, want to preserve as much privilege as possible over documents that are kind of created during the course of the investigation or the final findings as well. I mean, there are nuances, as you kind of heard from Payel and from Vyapak, but clearly that's not something that you want to release to the public domain and kind of, give up on privilege altogether. So that's the reason why companies hold that, close to their, or don't disclose them.
Sure. No, that's very helpful, and I hope that answers Krishna Kishore's question. And one interesting question when Gagan, you possibly were not there. One question was, what are the relevant qualification one must have to specialize in forensic investigation? Maybe
Sure.
your two bit
Sure,
of
I
it.
think that's interesting. And sorry, I think I was
That's
on the dark side of the moon. I lost radio connection possibly because of that. That's a very interesting question. And to me, the only qualification one needs to have is possibly a mindset. I think a basic qualification. When I look at my team today, there was a point of time, early 2000s when our team was predominantly accountants. But today, other than legal, maybe we've got a couple of lawyers who also have other qualifications, but we don't really practice legal work. It's basically I've got technology evangelists, I got accountants, I got intelligence professionals, I got former police officers, former military officers. So I think the key is having an inquiring mind. And to me, it's always about the mindset. I've seen the most qualified people fall flat on their faces when faced with investigation. And I've seen an analyst who just joined 3 days back, cracking the biggest of the cases because he has a mindset. So for me, a career in forensic is all about mindset. Either you have it or you don't. It's as simple as that.
sure. And we'll come to the point of the technology as we go along, because I think we go to the next set of questions which Alipak has already have in his mind and possibly itching to ask. And we'll take the other questions from the participants from Arvind and Sonali little bit later. But Alipak, if you want to go to the next set of questions that we have for Gagan and Gopi. You are on mute, Alipak.
Yeah. So in terms of preparation for investigation, so Gagan, this question is to you. In your vast experience, how does one prepare for an investigation? So what would be your sort of key takeaways? I mean, maybe you could list out 5 or 7 points. When you're preparing, what are the steps that you do? I mean, we understand that. I mean, as lawyers, when we sit down for an interview, I mean, it involves a huge amount of preparation, going through numerous documents. But how to sum it up, what would be the 5 or 7 points that one needs to keep in mind before the conduct of investigation?
Sorry, thank you. Thanks for pointing that out. I think the way one looks at an investigation, and let me just draw a parallel to a crisis. How do you really prepare for a crisis? How do you really prepare for something you don't know? So I think in reality, and on a very practical perspective, there's only 1, 2 or 3 things. Actually, I don't even think it's 5 or 7. But the first is making sure that you have a protocol or a standard by which you look at all investigative matters that come up. So to me, if you're ad hoc, if you are shooting from the hip, if you are letting it go to different people, different places, without having an overarching approach and a philosophy on how you deal with investigations, more often than not, you will fall flat on your faces because people are going to poke holes. Why did you do something in X and not in Y? Or why was it done in a certain way and not done in a certain way? Is there bias? You're just going to spend all your life talking about, different things. So to me, the first and the most important thing is making sure that your philosophy, your approach to investigations is set. The second part I'm going to pick on what Gopi said before is triage. Now, as a big company or as a large company, you're going to have hundreds of cases possibly coming to you. Most companies we work with, there is no dearth of whistleblower complaints. Everything from the canteen food is wrong to I got harassed or I have disrespectful behavior to fraud to collusion. It's all going to come to you. So how do you really put scant investigation resources? Nobody's got hundreds of people on investigations team sitting, and having outside counsel, outside experts involved is costly at the end of the day. I mean, there is a cost involved. I won't say it's costly, but there is a cost involved at the end of the day. So how do you really put investigation resources to where you need to? And to me, the triage comes, it becomes extremely important. And third and the last is making sure that the outcomes, of an investigation are looked up in a certain standard. And the remedial action that one needs to take is again defined in a matrix. There is a consequence matrix that's established. There is a clear articulation of how it works, because you don't want to have the different judgments applied to to the same set of circumstances coming out of different investigations. So I don't know about 5 or 6, but I think to me, these 3 are the most important points, because really you can't prepare for what you don't know. Every investigation tends to be different. There's a different nuance to it. There's a different level of management involved. There's a different complexity, different third party, different people, different issue. So how do you really, try to build all into an ecosystem? It can only come through if you've got good policies, procedures, processes against which
So,
you run an investigation like that.
yeah, I think only one point I may want to add here, Gagan, is the critical part that one needs to take into account is preservation of data or preservation of expected or anticipated evidence. Now, obviously, you don't know where that evidence lie, what is the data, who are the custodians. Initially, only 2, 3 names pop up, and then it becomes 7. But I think the most critical part is you need to map out how are you going to preserve your data. Therefore, sending out emails for legal holds. A lot of companies have a policy of deleting data or deleting server data after 6 months, 1 year. So how do you preserve the past data if there is an ongoing investigation?
Yeah.
Who are the people whose data will be preserved? How are they informed without losing the issues of privilege and confidentiality? I think, in my view, that's the most critical part, because investigation may take 4 weeks, 6 weeks, sometimes 3 months or 6 months. And at the end of that period, if you find that the data is tampered, modified, deleted, or not preserved in the form and manner, then basically you are not able to conclude the topic or the issues that you are dealing with. And two, who are the broad characters, dramatis personae, as we say, involved, and putting them on some notice, some hold. I think that two aspects, in my view, at least from a legal perspective, we tell the client initially that you need to actually identify some of these aspects early on. uh, it is still based on assumptions, presumptions, but to the extent we can manage that. Otherwise, you keep looking at one side of the story and the other side gets vanished. So I think that's, in my view, critical. But Gopi, you have any point on that? Otherwise we can move on to the next topic.
No, Vyapak, I think you've covered it perfectly. The only thing that I'd kind of add is obviously kind of,
Gopi, I think you're
as
on mute.
I've come off
Yeah,
mute now, so hopefully you can hear me.
yeah,
Uh,
perfect.
the only other thing that I'd add is, as you kind of build your plan, kind of have checkpoints to see where the investigation is going. And I talked about it a little earlier, but one of the key elements of those checkpoints is also kind of determining materiality of the issue, right? So that, I think, will also drive potential disclosure requirements. So keep that in mind as you're kind of going through an investigation, and almost bake that into your plan is the only thing I'd add there.
Sure. Yeah, thank you.
So, Vyapak, the only other point which I thought we often get asked that can you record the investigation? I mean, during the process of interview, this is a very common question which a lot of people ask us. I think in terms of best practice, we never record it. While we maintain a detailed notes, and that sort of forms the basis of report if sought at a later point in time. But as a matter of practice, we do not record investigations. And I thought I'll just share this because a lot of times we are asked this question.
So I think moving forward, and now since we have the do's and don'ts in terms of how you go about initially, how you conduct the investigation, identify the people, interview them, put the detailed notes. There are other aspects which apply beyond Indian scenarios. I think Gopi touched UK Bribery Act. There are US FCPA requirements, Sarbanes-Oxley. So, Payel, how do you have any like 2 minute view on those aspects as to how do you deal with those? Are they commonly seen in your experience, and is there anything more to be done at that stage, or you can handle it internally in India?
I think I'm going to start by caveating that I am a Indian qualified lawyer, so I cannot talk about the legality and what needs to be done under US and UK laws. But as an Indian lawyer, when we are dealing with the MNC, what's foremost and I think important for us to understand that there are implications of the actions that are happening back in India, which could be there for a US subsidiary or a company which has subsidiary or joint ventures in the other jurisdictions. I'll try and break it into two parts. When it comes to FCPA, the popular aspect of which is known to everyone is the anti-corruption part, where you're dealing with bribes which are not, you cannot engage in giving and taking bribes under the FCPA, deals with books and record keeping. And I think that's also very critical. I mean, a SEC or a DOJ might start an investigation into internal bookkeeping and records, which can then spiral into and move into an issue of anti-corruption itself. So FCPA cannot be looked at in a very narrow manner that, okay, this is something which applies to US order when I am looking at the Indian subsidiary. Typically, nowadays, we work in investigations which have a cross-border element in it. Maybe I'm working or representing a client which has its offices across the globe, and specifically maybe under US. So all the three legislations comes into place: the FCPA, the UK Bribery Act, and to some extent our Prevention of Corruption Act in India. I think that's the least of the threshold which one needs to cross, because you have higher thresholds to cross when it comes to UK bribery and FCPA. So when you're doing an investigation, you need to ensure that the protocols which you are maintaining, the process which you are following are in adherence to that standards as well. A very simple example like what Vyapak mentioned is data preservation is the most critical. Now, how much time do you go back to see till what time that data needs to be preserved? Now, FCPA clearly gives us a 5-year look back. So do I need to go back and preserve the data for the past 5 years? Or is it about an incident which happened only maybe in the last 1 year? So I just do a 1-year holdback and be aware of the fact that if later at a later stage, the regulator decides to open up an investigation, I am okay to answering the fact that I did only a 1-year look back and I did not go into 5-year look back. The next part of it is obviously privilege also. As I said earlier, privilege has a different threshold and different rules apply across jurisdictions. So privilege under which law are you applying when you're conducting the investigation? It's immaterial, it's happening in India, but is it required to comply with the standard which needs to be maintained before UK court? I think the last concept is we have multiple jurisdictions, we have multiple trigger points, we have multiple, and as I said, there is no straight jacket, or I would say a one size fits all approach. So I cannot close my eyes to how a US regulator or a UK regulator will look at it. And at the same, I think that's the reason the interplay of all these jurisdictions plays a very critical role. So do your investigation, but keep in mind what other laws can apply and which other regulators can come behind your back. Maybe not today, but 5 years down the lane. So you need to keep all your precautions in mind.
Sure. Alipak, you want to take the next question with Gagan?
Yeah, sure. So I think the next question which we had was, I mean, recently there has been a lot of news about the new company's auditors report order 2020. So could you please throw some light on its implications? People are talking about it. I think since we have you, you are the right expert to discuss this. I think if you can just sort of
Sure.
educate us.
Also, Gagan, you may want to because I think there are quite a few questions from participants about the disclosure post investigations, about the report and the compliance under different laws, including federal. We deal with that specifically for each participant. We are extending this session by another 20 minutes or so. We'll go up to 4:30 because I think there are quite a few questions to answer. But if you can answer the aspect of Caro, and then we'll take questions which are, from Divyang Majmundar, Mohan Pinse, and others immediately after that.
Sure. So, firstly, I have to start with a disclaimer that I gave up being an auditor 20 years ago when I figured out that I would never be in a position to sign financial statements. So I have to say the first big audit I handled, most of the management ended up going behind bars. And that's when I decided it's better to just give up auditing all and move to the dark side of doing forensic work. Having said that, being an accountant, a lot of my work actually comes, on the back and, both advising auditors and also looking at advising companies on their interactions with auditors. I think, the new Caro order, to me, a couple of things which are very worth noting. Of course, I won't get into other than the fraud aspects, but relating to fraud aspects, I think the first point is that whether there's any fraud that has been noticed or reported during the year, if yes, the nature of the amount involved has to be indicated. So, this is very similar to the Caro of 2016. I won't really delve on that much. I think it's pretty much the same. The second is whether any report filed by the auditors in ADT 4 as prescribed by Rule 13 with the central government, if an auditor has, come across this, he has to report. I think this is interesting. Vyapak, over the last couple of years, I've seen a number of these being made. Some of them are sub judice. I won't be able to talk on them, unfortunately, with the examples because I'm involved in a few of those. But I think it's really important that auditors have started reporting it. And I think, to me, that's the right thing. I think I want to draw a genesis here back to, what happened in the US post Enron and when we had the SAS 99 guidance that came in, which was basically the consideration of fraud in a financial statement audit. And Section 10 of the SEC, that, 10A of the SEC that came out at that time. It was very interesting because it said that basically that if an auditor did not see the company doing the right steps, if they reported an illegal act, they were supposed to make they were duty bound to report it to the SEC. And I think we moved the needle to India a good number of years later. But I think when I look at the current Caro, it's pretty much, the current regulations are that if the company doesn't seem to think that what you are raising is interesting, and they do not want to do an effective investigation on it. And believe me, where we have been auditors, we have come across those situations. The point is, how do you then do it? And then how do you make a report into the central government? So we see more and more of that happening. And as things go with the liabilities, with NAFRA now becoming increasingly active, we've seen what they are doing in this space and the number of investigations happening in India, I would expect to see more and more. Lastly, the last thing on fraud, which I think was really important, was the whistleblower complaints, and requiring the auditor to basically confirm that they looked at all whistleblower. This is very interesting. Number of clients of mine, would give a sort of a summary to the auditors saying, here are the 100 complaints. Auditor, depending on what was described in that sheet, would pick 5 or 6 because obviously, when you got 200 complaints, you may not want to look at all if it doesn't have a financial statement impact. But then, you would look at those in detail and you would look at everything and then satisfy yourself. But I think this one, basically, according to me, requires an auditor to sit and look at each and every complaint and see what the company has done with it. Not reinvestigate it, but satisfy himself or herself that, what has been reported has been looked at. So it can no longer be a case where the company is saying complaint came, we didn't do anything because we didn't feel there was a need to it. I mean, I'm sorry, there's no feeling anymore. That feeling has to be backed by tangible evidence. Because today, when an auditor is going to be sitting in front of a regulator, let's say a complaint came in against a person in charge of financial reporting, and the company did not do anything saying we don't find any merit in this complaint, and they failed to do an inquiry. You don't want to be sitting in front of NAFRA trying to explain why you did not, probe it further, or why did not feel, other than the fact that the company said they did not want to do it. So today there has to be, if I may use the word, affirmative steps taken to satisfy yourself and a documentation of those efforts. To me, this is the real game changer. I think this will change the effort on which whistleblower complaints are looked at. Today, when companies are making representation to the auditors, it is going to be even more pressure on them to make sure that what they are telling the auditors is backed up by evidence. Audit committee members who are again sitting with the auditors going through, what whistleblower complaints have come, will again need to satisfy themselves that the company is, firstly, the thing was, has the company reported everything? But today, it's also a question of, has the company looked at everything that needed to be looked at? And what was not looked at? Why was it not looked at? And what were the circumstances around those? So to me,
Sure.
this is additional pressure. To me, this is additional oversight. And I think we will see a lot more impetus being put in, at least on behalf of the auditors, to go ahead and do this. I think
So maybe
this is
maybe more work coming your way, Gagan, because of this.
I would think more work coming everyone's way, because there's going to be more work on the audit committee's part. There's
Sure.
going to be more work on the management's part. And there is definitely going to be more work on the auditor's part. Now,
Sure.
the point. So I think, yeah, more work all around. But at the same time, I think the way I'm reading between the lines is there is more responsibility all around. So today, as
That's
an
true.
auditor, you will not be able to sit before a regulator and say, sorry, that complaint was
We
not
didn't do
shown to
it.
me, or sorry, we saw it, we say it didn't look much to us. I think that is a fundamental shift, and that is what worries me, because
So that also, yeah, no, that
sorry,
also there is a very interesting question from Divyang Majmudar saying, if fraud is detected in in-house investigation, is it obligatory to disclose this fact to regulator like SEBI or statutory auditor? And maybe Gopi, if you've been alongside Gagan, of course,
so Gopi, maybe you want
as
to go
to
first.
how do you look at those aspects? Because I think we are possibly the only country who is now defining fraud not only in its contract act or civil procedure like cheating, but we have a definition of fraud in Companies Act and the
Exactly.
consequent disclosures prescribed under the Companies Act. Caro specifically talks about fraud and responsibilities of statutory auditor to respond to those questions on fraud, which is now defined under Companies Act. And if you are listed, of course, SEBI things come in,
Yes.
and you have dealt with enough listed situations, Gopi. If you can give a little idea as to how those works, and of course, Gagan, please come in on this as well.
Yeah, so Divyang, I think, we kind of talked about this a little earlier as well. There is a question of materiality and all of that in determining what disclosures should be made to the regulator. And even the SEBI LODR kind of provides for a threshold beyond which is you are mandated to actually kind of make a disclosure to shareholders and investors. So there is, I think that's something to kind of keep in mind as you go through an investigation. And Gagan talked about the requirement to actually kind of make sure that the statutory auditor reviews all whistleblower complaints. So that's something that happens on a quarterly basis. The US listed, where investigations are conducted, actually, in our case, the statutory auditor also has to conduct shadow procedures to make sure that all of these issues were looked at and closed out. So the interplay between the investigation team, making a determination as to when or what is going to be disclosed to a regulator, and the statutory auditor is a very important aspect of investigations that can potentially have financial fraud involved. So that's a great question. But the answer is effectively depends. I mean, it depends on what you found. If there's financial aspects that has been unearthed by the investigation, then there is a potential need to disclose both to SEBI, and the statutory auditor anyway will see all of the investigations that were conducted during the course of the quarter.
Sure.
Gagan,
And
So I
also
think
from
just to add what I think, Gopi, thank you for something. I think that's very important. I think 2 or 3 very practical things I've seen over and above what Gopi has said. I think firstly, if it's a fraud that's perpetrated by senior management or those in charge of governance and control, the auditors tend to get very interested, and they should, because that's clearly you're relying on representations of people who are involved in that fraud, and so as to speak, the override of control starts coming into that. So that's a really important thing to determine what becomes reportable or not. Second, of course, is materiality. Is it just one transaction? The third, of course, is the scale, and is it really pervasive? Is it organization wide? Is it limited? So there are a lot of factors, and there is really no one template. I think literally, in the good old days, in the SEC rules, we do that, the SAB 99 sort of a adjustment where you'd kind of, you'd list everything down, see what impact it has, and then, look at it. Literally, one has to, in every little fraud, one has to look into everything, the financial impact, the impact of correcting the problem, what more things. So it's just quantifying those amounts becomes increasingly important. So if you find one transaction, that's enough under Indian law to, put someone in jail for fraud. But when you come to companies' books and accounts, you really have to quantify it, and you have a full handle of what really is the amount impacted, and that will determine your next course of action amongst which regulators to report to, how to report it, who will report it. So all those questions will then come down. It's literally like a waterfall. You just at each step will have to figure out, what is the flow going to be going down on that.
sure.
So thank you,
So
Gopi.
I
I think
think
that was very well.
yeah. So I think from our perspective, we look at it from 3 different ways. One is, of course, your Caro and the audit requirements, because now there are straight away, if you have detected fraud, I can understand you are still investigating I think one can always take a view that it is too early to say there was a fraud or there was no fraud, because either of that can go wrong as a disclosure, and you can actually be prosecuted for a wrong disclosure than the fraud element itself. So I think one threshold is how final you are in terms of your investigation. The second is, of course, your CARO and audit requirement disclosures. There, I don't know how materiality would work with the new 2020 order, and more guidance on that would help as to what is to be specifically disclosed by the company or the board to the statutory auditor, or it is only when statutory auditor asks that you have to say. But I think, in my view, that would become a norm, that everything will be disclosed to statutory auditor, because whistleblower complaints will get covered, fraud is getting covered, and so on and so forth. Third, to SEBI, I think materiality is the test, and it will remain that as a test so far as an external regulator disclosures are concerned. And then your Companies Act disclosure itself, which requires you to, inform the ROC and Ministry of Corporate Affairs, and there are thresholds. In fact, we have covered some of these aspects in one of our publications. Maybe we can circulate this separately as well to the people who have participated today. We have a detailed paper on internal investigations, which deals with some of these FAQs as well. There is uh, another question, if I may take, and that is also something which I think Alipak wanted to ask both of you, is what are the probable chances of fraud under COVID-19 in manufacturing company? Now, while the question from Sonali is specifically for manufacturing company, I think our general question both to you, Gopi and Gagan, was how do you see things changing around fraud and investigations, even beyond fraud or not limited to fraud post COVID-19? Do you have any, sense while the question is only limited to manufacturing company?
Sure. So Vyapak, I can go first, Gopi, if it's okay with you.
Absolutely.
Vyapak, there are two or three things which I personally see are going to become very, very relevant. The first and the foremost one, and this is the biggest challenge right now, is building trust around financial information. I think what COVID has done is it has, if there were frauds happening in an organization, it was easy because money was coming in, there was a cycle, there was a circle, transactions were happening. So it took a longer time for something to get detected. So I think the first and foremost, all stakeholders today, lenders are looking at companies with a different lens. Moratorium is going to finish next month. Then we'll know how much liquidity impact really is going to come. The shareholders are saying, is it really, if we see so much downturn in operations, is it really because, of COVID, or was there a problem in revenue recognition, or something was wrong? That's there. When we are doing stressed M&A right now with bailout, I mean, anyone, private equity investors are all looking at the financial information, same lens, trying to think, guys, okay, hang on. So much has gone down. How much of it is really COVID, and how much of it was genuinely like there was some fraud happening and we didn't know about? So to me, the biggest challenge companies are facing right now is building trust on financial information. Even within companies, CEOs are looking at divisional results, segment results, and thinking, okay, we've got to go behind the numbers a bit and really find out what it is. The second major impact that I'm seeing is on whistleblowing. See, we've always been a country, where people are in the office, they see something happening, or you're at a thing, and you saw it, you put two and two together in your mind, and you were able to report it. Now interactions are happening on a screen, on the phone, on WhatsApp, and there is little opportunity for other people to pick up clues from there. So whistleblowing, or the dynamics of whistleblowing, is going to change. We may have different sort of whistleblowers coming up, but to me, the flip side is what is going to be reported is actually probably going to be backed up by more tangible evidence rather than just a feeling. So I think there is going to be some adjustment to the way whistleblowing is going to happen. And the third, to me, this is actually an opportunity for most companies to really go back and relook at their controls. What's happened over the last 3 or 4 months? Business has changed so drastically that unless you are able to go back now and relook at fraud controls throughout your organization, because your fundamentals of doing business in most companies have changed. If you pick up manufacturing, your vendor base may have changed, your logistic providers may have changed, your third party interactions would have changed. So how do you make sure that your controls have kept pace with the changes that have impacted your business? So I think From a COVID-19 perspective, I think these three things to my mind are absolutely important, and most companies today, in some form or the other, are grappling with or thinking about. Gopi, over to you.
Thanks, Gagan. And I think really just one additional point to add is I think the way that we're working is kind of altered so dramatically in the past few months, also changed. And I think there's a couple of vulnerabilities to keep an eye out for. I mean, A is obviously kind of crime and those types of issues that are almost a consequence of moving to a work from home environment, but also just making sure that you've got adequate controls in access, and that's something that is not really for lawyers to comment on, but I've been working very closely with our risk management team and our infosec team to make sure that the permissions that people have, all of those are kind of reviewed on a regular basis, just to make sure that there are control points and minimize the risk of fraud at this time. I mean, but besides that, I haven't really seen any significant change in the way that fraud is being perpetrated.
Sure, thanks a lot. And I think you are right. I think Gagan did mention about the whole financials, and it applies to every company, because how do you manage your inventory numbers? How do you manage your calculations about the valuations? 4-5 months things have not worked, so what happens to the existing orders or existing inventory, raw materials and stuff like that? All of that would be questioned as we go along. There is also one interesting question on the report itself, and this goes to the aspect of how do you conclude your investigation? And question from Peswani, and maybe Gopi, if I can bring you in, because you have conducted an investigation, you have to do certain disclosures, but in a complicated investigation, right, you may have certain areas which you are not able to conclude, whether you are agreeing to the whistleblower black or white. There are some gray areas. So how do you go about closing the report, right? You make a full-blown report, you make conclusions, you make it known to the board, audit committee, what you disclose to the whistleblower, because all of that will be important, that things are taken care of completely at that level rather than escalate beyond organization and going to court or any other regulator.
Yeah, sure, Vyapak, and Tina is part of the WNS team. So hi, Tina. Just in terms of, it's a good question in terms of in-house counsel in particular, and I'll explain that.
Oh, I didn't know. You had planted a question as well.
It wasn't a plant, I can promise you.
Yeah, good.
But just in terms of
Go ahead.
The actions that follow an investigation, there are obviously scenarios where you cannot kind of conclusively find that a fraud has occurred or not. But what I found in a lot of situations is that post the investigation being completed, and particularly if allegations are unsubstantiated, there is still the need to go back and look at what remedial actions need to be taken. And this could be as simple as, is the compliance program effective enough? I mean, do we have adequate controls in high-risk areas within, the organization? So, there are, even if, the investigation is inconclusive, there are potentially steps that need to be taken by the company to make sure that you address the root causes of the the complaint in the first place, which is primarily around, making sure that you kind of fix controls, policies, procedures as required, and all of that has to be done. And there's potentially disciplinary action as well. So, you kind of make sure you go and execute on those. And that's an important aspect of conducting an internal investigation, or any investigation, is making sure that you see through the conclusion of the investigation with disciplinary action where appropriate. Because particularly in companies that are subject to foreign laws like the Sarbanes-Oxley or SEC regulations, you have to kind of follow the US sentencing guidelines in the way that you deal with disciplinary action as well. So
Sure.
I think that kind of nicely wraps up the tail end of the investigation.
Got it. Also, there is one question from Soham Shah, which talks about how to handle hoax complaints. I think obviously, you will always get complaints which are prima facie not genuine. I think it's a matter of, little bit of, probing into it before you spend disproportionate time on that. And that's the job, I guess, of the person who is handling the whistleblower complaints, and it comes through practice, experience, and the factors affecting the company. But obviously there is no right or wrong way to do it, but you do have to go through that process before you bring in hundreds of people on your team and spend thousands of hours. There is also one question from Mohan saying, can this investigation report be challenged? Yes, it can. And maybe Gopi, if you want to give your thought as to if you have seen some of those going papers even after the investigation or to courts in HR investigations and stuff like that. But
Yeah,
basic response is yes, it can be challenged.
Yeah, absolutely, Vyapak. And I think, you hit the nail on the head, which is effectively a lot of investigations that have disciplinary action and employee-related kind of disciplinary action. Those are, things that can be challenged in court. It very frequently does get challenged in court. And that's why it's important to make sure that, all of this evidence is preserved, the investigation is conducted properly, the recommendations are framed correctly, and, the management has taken the right action. So that's kind of, obviously very important. It also happens where, you've potentially had to report an issue to a regulator. You now have the regulator kind of looking at the work that is being done as part of the investigation. And if that's not to their satisfaction, you've potentially got an issue where the regulator themselves are going to kind of litigate the matter. So, yes, I mean, I think that's kind of a long answer to your question, but yeah, I think it is possible to be challenged in a court of law.
Sure. Also, I think Pushkar has one question. Maybe Payel, if you want to deal with that, and maybe that can be our last question, considering we are reaching end of the session. What are the remedies available to the whistleblower for filing an appeal? You touched upon the sexual harassment and the process, but maybe you want to deal with this separately.
Yeah, sure. Action is the very critical part. You're done with your investigation. And we dealt with the aspect of providing a report, whether it's an oral report or it's something which you are actually putting it on paper, because that also invites a lot of clarification. I think initially when we started with internal investigation, the very fact the companies used to get scared or the board used to get scared when you receive a whistleblower complaint. What if I don't address it? What happens to that situation? So the very fact is that whether the whistleblower is going to go and approach a regulator and actually go ahead and ensure that the regulator initiates a formal investigation into the process itself. So I think that's one remedy which is still open for the whistleblower to go ahead and not satisfied with it and actually knock the doors of the authorities. And there are multiple authorities. So they can decide whether they want to get into multiple I would say forums, do forum shopping and go ahead with various litigation or investigation route to ensure their grievances are met. I think the only way to ensure from a company's perspective is if such a thing happens, it's not always that in an investigation you find out something, not necessarily, but you might find during the process there are enough gaps or loopholes in the process which need to be tightened or policies and procedures which are not in place. So even if the end result is not a requirement of giving a warning or giving a termination or anything of that sort, as long as you have a thorough investigation done and those gaps are filled in, I think it's a good enough defense or a which is available with the company to deal with such kind of issues which are raised by the whistleblower in future.
Yeah, thanks a lot, Payel. And maybe unless Alipak, you have any question, I think if there are final comments from Gopi or Gagan, I think we are very close to 4:30. We'll let everyone go.
Yeah.
And then I think Nishith Bhai, I see he's also there. Maybe he wants to have a 1 minute before we close.
Yeah, I think everybody has enough of I don't want to add too much of nuisance to the, but I must say it was very interesting. Each one of you had very interesting point, good stories and practical experience. So I really want to thank you personally. I've been on the call for last hour and a half, right from the word go. It's excellent, excellent, I think. And I'm very happy that we have had the opportunity of having you with us. And let's keep up some of these interesting dialogue going on. Yeah. So
Sure.
thank you once
Nishith,
again. Thank you so much. Thank
Thank
you,
you.
Alipak.
Thank you, everyone. And thank you to all of us. Thank you, July. Thank you very
Thank
much.
you.